The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Thank you and good morning. Our first case is Sandhill Amusement, Inc. and Gift Surplus, LLC versus State of North Carolina et al. Before we hear from the appellant, I want to note that Justices Irvin and Berger are recused in this case. That being said, we'll hear from the appellant.
May it please the court. My name is Beth Brooks-Scher, and I represent Gift Surplus and Sandhill's Amusement in this case. With the court's permission, I would like to reserve 5 minutes of my time for rebuttal. In the years leading up to trial, state and local law enforcement officials crisscrossed this state, trying to convince anyone who had actually interacted with the sweepstakes promotion that it was unlawful. Law enforcement's refusal to accept the determination of everyone who had actually seen this sweepstakes promotion and this video display in open court is what ultimately drove Gift Surplus to file this declaratory judgment action. After years of discovery, the parties went to trial before Rule 2.1 Judge Watson and chose to waive their right to a jury trial. Ultimately, the case proceeded to trial with each party presenting its best evidence and theories as to why this sweepstakes promotion was legal or illegal, and the trial court found in my client's favor. Nevertheless, the state convinced the Court of Appeals that the fact finder was compelled to rule in this case in the state's favor. But not even the Court of Appeals could agree as to why Judge Watson was wrong. The fractured nature of the Court of Appeals decision has produced what I admit are voluminous briefs in this case. But I think that we can streamline our conversation here by noting a couple of points, 4 in particular, on which the state and my client appear to agree. First of all, the sweepstakes statute only bans sweepstakes conducted through video games that are not dependent on skill or dexterity. Second, in this sweepstakes promotion, there is one video game, not 2, not 3, one video game. And every sweepstake entrant that successfully completes that video game will win a prize. Conversely, participants who do not successfully complete that game will not win a prize. And third, consideration is not required to participate in the sweepstakes promotion. And fourth, Gift Surplus's gift cards can be used to purchase physical products and social gaming products for which there is an existing and a growing market. Turning to the arguments in this case, as I noted, there is an agreement in this case that the Court of Appeals majority erred in rejecting the predominant factor test set out by this court in Sandhill. To the Solicitor General and Mr. Doggett's credit, they have admitted that that is incorrect, and therefore we would ask that the Court of Appeals decision majority be vacated on that basis. Unless the court has any specific questions about that, I'll rely on the arguments in my brief, and I'll turn to why the sweepstakes promotion is legal under the predominant factor test. In Sandhills, this court noted that whether or not a game is dependent on skill or dexterity for purposes of the sweepstakes statute is not based upon whether a game contains an element of skill or an element of chance, but which of these is the dominating element that determines the results of the game. That is the standard set out in Sandhills, and there are some auxiliary principles set out in Sandhills as well. The final outcome test, the requirement that each game has to depend on skill or dexterity. What the state and I disagree on is whether or not that is a question of fact or is that a question of law. In this case, we contend that it is a facts-bound question. Sandhills itself notes that whether or not a game is dependent on skill or dexterity is found based upon the facts of each particular game. As we've noted in our brief, Every other jurisdiction that has specifically addressed whether the predominant factor test is a game of skill or dexterity has said it's a question of fact for the fact finder. Now, that doesn't mean that there is no appellate review. Of course, there's always appellate review. But what that means is, as long as there is any competent evidence in the record, the appellate court will affirm the trial tribunal's determination that this is a game of skill as opposed to a game of chance. And I don't like generally to read from briefs, but in this case, I find it particularly interesting that tomorrow the state is bringing another case to you. And I think it sums up very well our position about what the proper standard of review is in this case. And it's called State v. Taylor. And the state in its brief says, contrary to the decision below, independent review is not licensed for a court to conduct a freewheeling re-examination of the record and find facts for itself. The state must prove its case beyond a reasonable doubt to a jury of 12 North Carolinians. Independent review does not require the state to prove its case a second time to a panel of appellate judges. And I think that that is what the government in this case is expecting us to do. But the reason why it wants to do that is because there is competent evidence in this record that these games are predominated by skill and dexterity. Most important, the trial tribunal, the fact finder in this case, actually interacted with these games. I can't wheel these machines into your homes or into your chambers and show you how the game plays, how skill and dexterity work. That's something that is reserved for the fact finder. But on top of that, there was laboratory data in this case showing that skill predominates over chance. Indeed, my client has intentionally taken chance out of the game itself. There was expert testimony that this game's outcome depends on skill. And then finally, there was the comparison in this case of other games that the state has certified as meeting the skill-based requirement. And the testimony was that our games far exceeded the skill required by the state's Tribal Commission on Certification of Games for the games at the Cherokee Casino. So these type of things show that there is competent evidence in this record to support the trial tribunal's findings. But even if under the court were to conduct de novo review, it is undisputed in this case that this game, if you're just looking at the game, it is a game whose outcome is dependent on skill or dexterity. And I think that's kind of important because in the case that follows us, the court's going to see a sweepstakes that is being conducted through a game of chance, and then it also has a game of skill on top of it. And I think that's very different because the statute says that if you're conducting that sweepstakes through a game of chance, then it can be illegal. Now, I'm not here to argue what the legality or how those two balance one another out because there's a skill-based game and a chance-based game. But in this particular sweepstakes promotion, there's one game, and it is dependent on the skill or dexterity of the players. I'm sorry, was somebody trying to answer a question? Ask a question?
I'm sorry, I forgot that I would be on mute. Thank you, Ms. Sherrill. In terms of talking about the skill and dexterity being a factor in every game play that's conducted, do I recall correctly that there is a figure that in 75% of the games, no matter how the player plays, that player will win nothing?
That is not the case anymore, Justice Morgan. In a prior sweepstakes promotion that this court addressed, and particularly Justice Urban's opinion, there was a factor that there was zero value prizes. So in 75% of the games, you could not win any prize. And the problem with that was because skill could not impact your ability to win a prize. There was no prize to win. The skill in those particular games were irrelevant. In this game, all those zero value prizes have been eliminated. And instead, they have been replaced with cash value prizes. So in this case, in 100% of games, if a player exercises skill and dexterity, they will walk away with a cash prize. Now, the government wants to say, well, it's not a significant prize, and the prize isn't enough. But that's not what the statute says. The prize is defined under the statute as anything of value. And of course, whether or not you're gambling doesn't depend on whether you're playing a poker for pennies or if you're playing it for tens of thousands of dollars. Gambling is gambling if there is some prize at the end. And so we would contend that a cash value prize is a prize. And that's quite frankly, Justice Ervin was right when he pointed out that the skill in the prior sweepstakes promotion couldn't impact. It had no role in those games. But now that has been eliminated.
Is this the one, therefore, as I'm updating myself, and thanks for allowing me to get your version of the update, every player will win at least a few cents on a play?
On each game, that's correct. That's correct. But let me clarify that, if I may. If they successfully complete the matching game. Of course, there is no automatic winners. You have to successfully complete the matching game.
In terms of the aspect of a few cents being able to be won at least every time, is this significant enough of a winning to take this out of being what the state would challenge as being a game of chance, and you say that it's a game of skill, even based upon the relative limited amount of what can be won, guaranteed?
Well, yes, Justice Morgan, and I think the reason why is there's no consideration in this case. So it's not like anyone can ever lose any money. Consideration is not required to participate in the sweepstakes promotion. All sweepstakes entries are given freely. And as I noted when I talked to you earlier, is that penny poker is gambling, regardless of whether you are gambling for pennies or tens of thousands of dollars. The size of the prize is not relevant about whether or not it is a game of skill or a game of chance. And the government in this case, I think, kind of likes to twist the statute by saying, don't look at the game. Don't look at the game. Look that it's a sweepstakes. And what they're trying to do is take two different statutory definitions in this sweepstakes promotions and combine them together and say, well, in order to be a skill-based game, the prizes cannot be awarded randomly. But by definition, all sweepstakes prizes are awarded randomly. That's the very definition of a sweepstakes promotion. So when you go and you participate in McDonald's Monopoly, and I'm referencing that because I think that's the one that most people are familiar with. You don't get to go into McDonald's and say, I want the package of fries that has Boardwalk on it. Rather, you go in and you get your package, you get your free sweepstakes entry with your purchase or without your purchase, because just like every other sweepstake, there is an option to get free prizes or get sweepstakes entry without a purchase. But you're given that sweepstakes entry, it's selected randomly, and that's exactly what happens here. I think the other thing to remember is there's nothing entertaining about how that prize is selected in this case. The evidence presented at trial is that all behind the scenes, there is a pool of prizes. And in any sweepstakes promotion, you have a pool of prizes. It has to be a finite amount because you have to give the players the odds of winning. So 250,000 prizes. And what the computer does before any game comes up is shakes those prizes up and pulls out a prize from the available prizes that are available. And then it determines that prize, locks it in, and then the game is put up. The game, then, you have to create the matching game. But it wouldn't matter if every single matching game was the same. So, for example, if every time the sweepstakes the video game came up, it was 1, 2, 3, 4, 5, 6, 7, 8, 9. And your job as the sweepstakes entrant was to put all the even numbers on the middle line. If every single time you did that, it couldn't change what the prize is, because the prize is locked in. Any more than when you reveal the prize by pulling off the front of the McDonald's piece, it can't change what the prize is.
One difference between the McDonald's version that you're mentioning and what we have here is an entertaining display. And how would the entertaining display angle figure into this as you use that McDonald's Monopoly game as a standard that you say passes muster versus the Court of Appeals majority here looking at the entertaining display as being an issue?
Well, the statute itself defines what an entertaining display is. And an entertaining display, as we know from both Sandhills and from the words of the statute, is only a video game whose outcome is not dependent on skill or dexterity. Now, there are 7 listed games that you cannot use. And if you're conducting that sweepstakes that sweepstakes promotion through one of those 7 listed games, then the predominant factor test doesn't apply. But there's no question here that that's not going on. Rather, the government is trying to argue this is illegal under that catch-all provision. And that catch-all provision says that in order to be an entertaining display, the sweepstakes promotion has to be conducted through a video game not dependent on the skill or dexterity of the player that is played while revealing a prize as a result of an entry into a sweepstakes entry. And so I think there's 2 components there. It's not just all video games. It's just those video games that are not dependent on the skill and dexterity of the player. To do what? To reveal a prize. Not to choose a prize, to reveal a prize. And that word does state or suggest that the prize has already been pre-selected in the case. And
well, let me ask you about that. I'm trying to figure out how this game exactly works. You said a couple times that the prize in this particular game is predetermined randomly and locked in, I think was the word you used. And so I just want to make sure I understand it correctly. When you sit down at the video display to do the whatever it is that requires some degree of skill, you can't affect the size of the prize. It's already locked in there, right? And so the only thing that you can do is fail to get it by not exercising the skill on the video display. Is that right?
that's correct, Justice Hudson. But by its very nature, that is what a sweepstakes is. The sweepstakes statute doesn't outlaw just anything generally. It outlaws a very specific thing, and it outlaws sweepstakes. And what are sweepstakes? Look at the statute. Any game, advertising scheme, plan, or promotion which a person may enter to win or become eligible to receive any prize, the termination of which is based upon chance. So the government, I'm sorry, Justice.
So let me ask you, if you sit down at the display that has this already predetermined prize locked in, and you want to know what it is, can you reveal what the prize is without doing the little game?
No, you have to do the game in order to see what the prize is. It's not going to, at least that's my understanding. And I want to be clear, I don't have the game in front of me. I wasn't at trial. And I think that's part of the reason why this is so important to leave this to the fact finder. The fact finder can answer all of these questions for you and ask these questions and actually see it. But my understanding is that the only way to see what the prize is, and more importantly to claim the prize, is to figure out what prize, the match you have to make in order to get the prize.
So if you can't affect by, no matter how skilled you are at that part, affect the size or the nature of the prize because it's already there locked in. Is that right?
Correct. And that, again, every sweepstakes entry is associated with, it's pulled out of that prize. But again, that is the very nature of a sweepstakes promotion. So if I could affect which particular prize that I was receiving, it wouldn't be a sweepstakes. It would be a skill-based contest. And the statute doesn't cover skill-based contests. But I think that the government's concession that there are some video sweepstakes which are lawful and other video sweepstakes promotions which are unlawful, I think that's important because the only way under the government's theory that a video sweepstakes statute can be legal is if it's illegal for the prizes to be selected randomly. And the government even, I think, concedes that even if the person came up and were playing a game of chess, that would not be a skill-based game to the government. And I think that's wrong. I think that whether or not, yes, Justice Earls?
Well, I do want to understand what's left of the statute, what's left as a legal game. Applying Sandhills 1, then Judge Irvin's dissent in that case, because he ultimately says that even assuming that this single nudge is makes this a skill-based game, even assuming that it is still comes under the statute. It is no longer legal under the statute as the game was played in Sandhills 1 because the outcome was determined by chance. What prize you get is determined by chance. But in every sweepstakes, what prize you get is determined by chance. So if a single nudge was still assumed to be a skill game and yet didn't make this permissible under the statute, how are the changes that have happened that make it a double nudge, or even how is it that the trial court's determination that it's a skill game lead to a different outcome than what was decided in Sandhills 1? And how is there really anything left that could be legal under the statute?
Well, Justice Earls, first of all, I want to first point out that the preliminary injunction, it's always likelihood of success. There is no determination about whether or not. But I think the difference is because the sweepstakes promotion changed, and the biggest change is the winner every time. And in Sandhills, Justice Irvin didn't say all of the games lack skill. He says when you don't have a winner every time, it'll result in the playing of certain games in which the player will be unable to win anything of value, regardless of the skill or dexterity that he or she displays. And I think that's important. He was pointing out in the prior sweepstakes promotion, in 75% of the games, you couldn't win anything of value because there was no value associated with those sweepstakes entries. That has changed, and those certain games have been eliminated. Now, in each and every game, the player is able to exercise skill and dexterity to win a prize. I don't think that Sandhills says that every player has to be playing for the biggest prize or substantial prizes. And indeed, this interpretation of the statute is so foreign that not even the government argued it in the trial court. Nowhere did the government say, everybody has to win a prize. Everybody has to win substantial prizes. And there's a distinction between token and non-token prizes. And don't get me wrong. I concede that if the General Assembly wanted to change this statute to say all prizes have to be the same, or we're going to outlaw all video sweepstakes promotions, they could do that, but they haven't. And as we've noted in our brief, it is not because law enforcement has not tried. They have repeatedly went to the General Assembly and asked them to change this statute, and the General Assembly has not acted. And so what has happened here? They're coming to the court and they're saying things like, read criminal laws broadly. I mean, just thinking about that for a moment. Read criminal laws broadly. that violates every principle of due process that I know. And I think that if the government has to argue, ignore the plain definition of the statute, read these criminal statutes broadly to outlaw the spirit of what we think the General Assembly meant to outlaw. I think that's a very good indicator that this statute does not outlaw what the government wants it to. And I have just a couple of minutes left, and obviously I'll answer any questions, but I think it's also important to remember what this is. This is a criminal statute. People can go to jail for violating this statute. And if after all this time, the government, after 7 years in a trial, couldn't come up with a theory that, oh, well, only if the sweepstakes promotion doesn't offer token prizes, how could individuals of ordinary intelligence, without legal training, read this statute and know that they were subjecting themselves to criminal?
Ms. Scher.
Yes, Justice Barringer.
To follow up with what some of the other justices have talked about regarding the small prize and the fact that the prizes are random, how do you reconcile that with the language that whether skill or chance determines the final outcome and whether chance can override or thwart the exercise of skill? It seems to me that there's a conflict there if all you're doing is playing a skill game that you might win a few pennies. How do you overcome the fact that the skill may or may not override or thwart that exercise of skill, since the prize is random and it is very possibly very small compared to the skill that's having to be displayed?
Well, Justice Barringer, I think that the answer is that the sweepstakes statute requires prizes to be selected randomly. That's the common definition.
But ma'am, isn't it true that while these prizes are selected randomly, it's your client who chooses what's going to be in that random sample?
Well, that's the case for every sweepstakes statute.
Oh, well, that's absolutely true. But we're looking factually at this particular, you want us to look at the facts, and the facts here are that only pennies could be won, and the person playing with some degree of skill doesn't know whether they're playing for the grand prize or for very small amounts. I think there's a challenge here to reconcile that, especially given this particular language. How do you respond?
Well, my answer would be that in most sweepstakes promotions, most people don't win any prizes. And in this particular sweepstakes promotion, you have a pool of prizes, and those pools in any sweepstakes promotion are set by the promoter. That's by definition what a sweepstakes is. The question is not whether or not the final outcome determines whether you get McMillions. The question is whether or not your skill impacts your ability to get a particular prize. And unless the court has any, I'm always happy to answer questions. I'd like to reserve the rest of my time for a rebuttal.
Thank you, Ms. Scher.
Thank you, counsel. This time we'll hear from the appellee.
May it please the court. My name is Jim Doggett, and I represent the governor and the other defendants in this case. In 2010, the General Assembly banned video sweepstakes because it concluded that they promote the same vice and dissipation as gambling. Specifically, they promote dissipation because they can lead to North Carolinians impoverishing themselves by trying to win riches by playing games that prevent the vast majority of players from doing so. Since 2010, the plaintiffs in this case have tried to prevent law enforcement officials from protecting the people of North Carolina from video sweepstakes in court. This court, however, has already ruled against them twice. And below, the Court of Appeals also held that their sweepstakes is illegal. They now ask this court to reverse that decision. This court should decline to do so for 3 reasons. First, plaintiffs are violating the video sweepstakes statute because chance predominates over skill in their sweepstakes games. Second, the Court of Appeals correctly reviewed the legality of their games de novo. And third, an alternate basis also exists for affirming the decision of the Court of Appeals. At trial, plaintiffs failed to show that they are running a legitimate business that is not simply a front for an illegal gambling ring. To address my first point, plaintiffs are violating the video sweepstakes statute. The video sweepstakes statute, as this court has already held, prohibits sweepstakes that are conducted through video games in which chance predominates over skill. And this court has also held that chance predominates over skill in a game when it can thwart the exercise of skill and control the outcome of a game. That is the case here. The largest prize that players can receive by playing plaintiff's games is $2,400. On 75% of turns, however, that receiving that prize is impossible. On those turns, players at most can only use their skill to receive several cents by playing. As a result, chance can thwart the exercise of skill because on 75% of turns, players can use no amount of skill to win the best prizes. And in response, plaintiff's primary response to this is that skill predominates here because players can always use their skill to receive at least several cents when they play a turn. But this court has already rejected those types of arguments a century ago. I'd specifically direct this court to the Lowe decision, where this court considered a button machine that sold buttons for 5 cents. But it wasn't just a regular button machine. It also randomly dispensed boxes of candy that were worth 10 times as much as the buttons. And so players, when they put users, when they put 5 cents into the machine, would sometimes receive a prize that was much larger than the value of what was regularly dispensed from the machine. And this court held that chance predominated in that machine, even though someone was always able to receive a 5-cent button from putting money into the machine. And that is exactly the situation we have here. It's exactly the situation. I'd also point this court to this court's decision in State v. Abbott, which was decided in the 1940s. And in that case, this court held similarly that chance predominates in traditional slot machines because it controls the financial return to the player. And so this is an unbelievably straightforward case. Plaintiffs say that the statute is ambiguous, but I would submit it is exactly the opposite. The General Assembly could not have made it any more clear what it wanted to accomplish in 2010. There was a pattern of evasion where sweepstakes operators were trying to evade North Carolina's ban on video poker and similar machines by conducting sweepstakes. And it said, okay, what we're going to do is we're going to ban sweepstakes when you conduct it through what is effectively the same thing as a video poker or other video gaming machine. And also in doing that, it referenced the skill and dexterity language that this court has used again and again in its gambling cases. And this court has already held that the statute incorporates the skill index, the typical chance versus skill predominance test that this court has applied for centuries. And so this case only calls on this court to apply a predominance test that was first announced in 1848 and that is since elaborated on to the undisputed facts in this game. And when this court does that, this is an unbelievably simple case. All this court has to do is apply cases like Lowe and Abbott, and it's holding in Sandhill that the sweepstakes statute incorporates cases like those and this court's traditional predominance cases.
Let me ask you a somewhat related question about the sort of history of all of this. In Hest, we addressed the constitutionality of sort of vis-a-vis the First Amendment, but in so doing, we summarized what the legislature was intending to do when it passed this legislation, and pointed out that in the preamble to the legislation, that the General Assembly noted that the problem that they wanted to address was the quote vice and dissipation that comes from encouraging repeated play and sitting at a video screen. And my question is the game involved here, whether it involves some degree of skill or not, any different from any of the earlier ones in terms of encouraging someone to, and requiring actually, to sit at a video display and do something in order to find out what the prize is.
Yes, that's exactly what the General Assembly wanted to address, and that's exactly what we have here. This is essentially.
Is this one any different than the others in that regard?
The only difference here is that this machine functions effectively like a slot machine, and the only difference is the symbols don't automatically stop in combinations that award prizes. Instead, players have to engage in nudging. But in many ways, that actually makes this game more perverse, because it can trick players into thinking that they can use their skill to actually win a substantial prize. And the opposite is true. This machine is designed so that on 75% of turns, players can only get a couple cents from playing and can never receive a large prize like $2,400. So in many ways, the way that this game is constructed is even more perverse and more likely to entrap North Carolinians. And that it's important to recognize this is a consumer protection statute, effectively. This is meant to protect North Carolinians from the many harms that from impoverishing themselves on playing essentially what are video poker machines, and then also to protect many North Carolinians from the secondary harms that flow from those machines. So this is exactly.
How does it impoverish you? How do you spend money on this particular game?
Well, a player first purchases a product, and then they receive free sweepstakes entries, and they play the machine until they're trying to win large prizes. But on 75% of turns, they just aren't going to receive a large prize. And
my understanding is that you can play without paying for anything. Is that correct?
Correct. That's right. You can receive a free sweepstakes entry. That's right.
And so how does it run the risk of impoverishing you if you play with a free entry?
Well, the important thing I think to look at is the preamble of the sweepstakes statute. And there the General Assembly found that these types of games encourage dissipation even when they promote purportedly products. And so what the General Assembly said is they looked at this and said, we don't believe that these are real businesses. We believe, and even if they are real businesses, we think what people are doing when they go and play these games is they don't value the products. These things are selling gift certificates and things like that that are printed out on a little piece of paper that look like a receipt. They're sitting there, they're going into a convenience store, they're going into a restaurant, they're going into a bar, they're going into a sweepstakes parlor, throwing money into these machines to get products they don't really want. And so the fact that people do receive or can receive a product in exchange for playing these games, that's precisely the evil that the General Assembly meant to address.
I would like to, if I may, I'd like to ask a question about the state's interpretation of this statute, because it sounds like you're saying that there are in fact no video sweepstakes games that would be legal under the statute. And if that's true, then why is the language that in the catch-all provision saying any other video game not dependent on skill or dexterity, why doesn't it just say any video game?
Well, just sort of, I have two responses to that. First, I think the way that the statute is drafted is simply a reflection of the legislative history we have here. Essentially, there was a statute, 14306(1)A, that banned video poker machines. And if you look at that statute and compare it to the sweepstakes statute, which is 14306(4), you'll see essentially what they said is, we don't want you to conduct a sweepstakes with one of those games that we prohibited in the video gaming statute. And so that's why the statute is drafted as it is. But I think there are potentially some video sweepstakes in which that would be operated through a video game in which skill would predominate. For example, imagine a video sweepstakes where the prizes would be determined by chance, and the prizes were a red teddy bear, a white teddy bear, and a blue teddy bear, and they all had the same value. And let's even say that the players, if they didn't like the teddy bear they got, could exchange one teddy bear for the one of the color they wanted. In that circumstance, chance would determine the prizes that would be awarded, and yet players could use their skill to receive a prize of approximately the same value as another prize. And there's other examples you can think of too. Imagine a sweepstakes, for example, that every time you entered, you would get 10 entries and you could play 10 times. And on 9 turns, there would be a cent prize. And on 1 turn, there would be a $10 prize. But every player got an equal chance to play those games and to win the $10 prize. In those circumstances, again, you would have a situation where all the players would be put on equal footing. All of them would have an equal chance to use their skill to win the game, and yet chance would still determine the prizes that are distributed.
Where from the text of the statute do you draw the conclusion that it makes illegal all video sweepstakes except those that award everyone a prize of the same value?
I think first, the statute prohibits operating sweepstakes through an entertaining display. It then defines an entertaining display to be a video game of chance. And that language incorporates the predominance test. And then this is a simple, straightforward application of the predominance test this court announced nearly 2 centuries ago. So I think that principle flows from the predominance test, which this court has already held, is incorporated into the statute itself.
Speaking of that, the concurrences from the Court of Appeals primarily look at, as the parties do, the skill and dexterity aspect of this versus a game of chance. But the Court of Appeals majority opinion does look more at the entertaining displays aspect. Do you feel as though this court should look more at the skill and dexterity angle here, or should look more towards what the majority focused on, which was entertaining displays?
Well, when this case was first on appeal, this court held properly that the statute incorporates the traditional predominance test, and we think that's the correct that's the correct interpretation of the statute. And this is a matter that this court has already settled, we think.
Should we be looking more then at that angle, or more at what the majority focused on in this case? Because of course, in terms of looking at all of this, it's all relevant, certainly, but in terms of looking at what we should focus our decision on here, since Sandhills 1 has been determined, where should we go with this one?
I think this court should just focus on the predominance test. And like I suggested earlier, this is an incredibly straightforward application of the predominance test that this court has already held is incorporated into the statute. And this court simply has to apply its decision in Lowe and apply its decision in Abbott. And after that, this case becomes very straightforward.
You raised also earlier that there is something of value that is obtained when one plays these games by way of the sweepstakes component, and that is they get a gift certificate or something of value. How should we look at this from an analysis standpoint, wherein you say that those products aren't really the object of the focus of the transaction, but more so the play itself? How should that fit into our analysis?
Well, just Morgan, I'm glad you asked that question, because I'd like to make something clear. We've made an argument both in our briefs under the sweepstakes statute, and we've also made an argument that separately this court could also conclude that the plaintiffs in this case are engaged in pretextual gambling. But those are 2 separate arguments that are distinct from one another. The pretext issue is entirely separate from the sweepstakes statute, and this court does not need to make any sort of finding of pretextual gambling to find a violation of the sweepstakes statute. In fact, that is precisely the reason that the General Assembly enacted the sweepstakes statute, because normally to show gambling is necessary to show chance, consideration, and a prize. And what the General Assembly did when it enacted the sweepstakes statute was it simply eliminated the consideration aspect. And so the only issue is whether or not the statute, whether or not these games award a prize, and whether or not chance predominates in the games. And so again, it comes back to the predominance test and simply making a straightforward application of this precedence.
So it sounds to me as though you're saying
Aspect of this. Having some audio issues. Can you hear me, Mr.
Yes.
Doggett? Okay. I wanted to ask you about the predominance aspect of this. And as I understand the game, and correct me if I'm wrong, As Ms. Scherer put it, the prize available to somebody who sits down at the video is predetermined and locked in. But before you ever sit down, what the prize that might be available to you is already set. The only thing that you can do by the nudging is not get it. You have by double nudging 2 chances to not get the prize, as I understand it. And so that's the aspect of skill, is whether you can actually get to the finish line by having the little things line up. Can you explain to me how in that scenario, which either chance or skill predominates when the prize is already set, but you can't get it unless you exercise the skill?
Of course, I think it's a straightforward application of precedent. The predominance test is that chance predominates when it can thwart the exercise of skill and control a game's outcome. And here, the outcomes of these games are the prizes that players receive. And so the most the players can do by exercising their skill is to lose a prize. And it's pretty clear. I mean, chance can control the game's outcomes, because on those games where you play and the symbols that allow you to win the largest prizes don't appear, there's nothing you can do to receive those prizes. You're always going to be limited to receiving several cents. And that's obvious to players when that occurs, because basically the reels on the games look very similar to the grid view that's available to everyone right here. What happens is a cent symbol appears in one of those screens, and all player can do is nudge one of those cent symbols up to the middle reel, and that's all they can do. And so they're limited to receiving several prizes on a turn. They can do nothing to change that at all.
But why wouldn't that be true of every sweepstakes?
Well, I think the important thing to understand is that the General Assembly did not enact the statute to endorse sweepstakes. It enacted the statute to prohibit them. And so the fact that the definition, go ahead, Justice Earls.
Well, but I really wanted to ask you about the predominance test in terms of whether it's a factual question or a legal question, because it sounds like you're arguing to us it's a question of law, and that doesn't seem to me to square with the concept that in a criminal prosecution the jury decides, as I understand it, whether chance or skill and dexterity predominate. And it also seems to be contrary. I'm curious your response to the argument made in the plaintiff's reply brief at page 13, where they point out several briefs where the state has argued that whether or not it's a game of chance or skill and dexterity predominate is a factual issue for a jury to decide.
So first, Justice Earls, just to address your second question first, I think plaintiffs have simply misrepresented to the court the position that the government has taken in prior cases. We filed a memorandum of additional authority where we submitted the full briefs. Plaintiffs only submitted excerpts of those briefs, and let me walk through them one by one. So let's start with the Joker Club brief. If you look at that brief, literally on the next page, after the page that plaintiffs exerted, the district attorney in that case argued that predominance was an issue of law. In the Eisen brief, I struggled to see where, if anything, the state said anything that was inconsistent with our position in this case. In the Stroop case, if you look at that brief, there appears to have been a throwaway argument at the end that predominance can only be reviewed by appellate courts when a game's rules are subject to common knowledge and therefore can be judicially noticed. And this court, if you read the Stroop decision, clearly did not accept that argument. And I'm not aware of any other instance where the state has made that argument. I would like to point out another part of the Stroop brief on page 6, where I think the state's arguments in that case precisely demonstrate why defendants should win in this case. And again, this is on page 6. The is invited at this point to the North Carolina cases which have determined various activities to be games of skill. In every one of them, all participants are given the same equipment and the same opportunity under the same conditions with the same possibilities of winning the same reward, And that is precisely the problem here. Players are not given the opportunity to use their skill to receive the same reward. On 75% of turns, players can only use their skill to receive several cents. So actually the parts of the briefs that plaintiffs chose not to submit to you reveal precisely why the defendant should win in this case. And to address the question of whether or not this is an issue of law or an issue of fact, this court has repeatedly held that when a mixed question of law or fact involves the application of legal principles to settled facts, then those issues are reviewed de novo. And that's what this court is called upon to do here. It's called upon to apply the predominance test to the undisputed facts on how these games are played. And if this court reviews its decision in Gupton in 1848, this court applied what can only be described as de novo review to resolve that question. This is plaintiff's argument in the reply brief seems to be that so long as a court mouths the correct legal standard, then all appellate review is automatically deferential as to the application of the law and facts, and that's just simply not correct. Plaintiff's own cases show that it's not correct. For example, in the reply brief, they cite a number of cases from the workers' compensation context that involved a determination of whether a worker had been injured within the course of their employment. And in 3 of those cases, Hoyle, Luter, and Roman, this court paid no deference at all to the fact finder's application of the law and fact and reversed the fact finder's conclusion. And this court takes that approach in a bevy of cases. For example, this court has held that when it determines if a claim is time barred under a statute of limitations, that application of the law to fact can be reviewed de novo. It is held that whether or not there's been a probable cause violation, appellate courts can review whether or not that application of the law to fact should be reversed de novo. It is held with respect to whether or not there's a double jeopardy violation that that application of the law to fact can be reversed de novo. And also importantly, in this context, when this court reviews the sufficiency of the evidence in a criminal case, that review is de novo. That review is de novo. And there are certainly many cases where questions about the sufficiency of the evidence present more of a factual inquiry, where there are disputes about the historical facts. But there are many cases, and I'm happy to point out examples to the court, when this court reviews the sufficiency of the evidence in a criminal case, it essentially applies what is a de novo factual review because there's no question about what happened. And the only issue is whether or not the law criminalizes certain conduct. So I strongly disagree with the suggestion that this is a pure issue of fact. I mean, when you think about it, that really makes no sense because there needs to be uniformity in the application of the state's gambling laws. And under the rule that plaintiffs have proposed, there could be widely divergent decisions based on a matter of fact. You could have one game that was very similar to another, and one fact finder could conclude it's legal, another could conclude that it's not, and the appellate courts would not be able to provide any guidance to address that issue. And I'd also strongly disagree with the suggestion.
Let me ask.
Go ahead.
Let me ask a quick question about that. Am I understanding you to argue that here we all know which part of the game involves chance and which part involves some degree of skill with the nudging, but the question of which predominates is the issue of law? Is that right? That's
right. That's this court. The issue, the factual issue here is how the games are played. Those are the historical facts that are at issue. And so that's all been settled. There's no disagreement. If you listen to the arguments, there's no disagreement between opposing counsel and myself about how these games are played. The only disagreement is about how the predominance test should be applied to these facts. And so that's the issue of law here.
I just want to make sure I was understanding.
And I'd also like to briefly point out that, again, I strongly disagree that every other jurisdiction has held that predominance is a factual issue. I mean, this is typical of the hyperbole that plaintiffs have engaged in this case over and over again. We cited a string cite in our brief where we show that there's not agreement on this. In particular, I direct this court to the Fifth Circuit's decision in Johnson v. Finney, where it held that predominance could be determined as a matter of law. I'd also direct this court to the Power Pick case from the Michigan Court of Appeals, which is again very similar. That case involved a contest where someone could pick out symbols within a magazine and then send in the number of symbols that appeared in the magazine, and then become eligible to a prize if they got it right. And there, the Michigan Court of Appeals held that chance predominated in that game because predominance turned on the legal meaning of undisputed facts. And again, that's precisely what we have here. I also like to point out that the federal cases they cite on supposedly mixed questions being reviewed deferentially do not support them. If this court reads the decisions in U.S. Bank and Manaski that address this issue, that plaintiffs' claims show that all mixed questions are reviewed deferentially, those cases actually say that when courts are called upon to elaborate on the law and to expound and amplify broad legal standards, those decisions should be reviewed de novo. And now in those cases, in fairness, the Supreme Court did hold that the specific issues in those cases should be reviewed deferentially. But that's because those issues were very different from what we have here. The North Carolina Court, this court and the North Carolina Court of Appeals have elaborated on the predominance test, starting with Gupton, following and concluding in Sandhill most recently, and has repeatedly over and over and over again elaborated a clear rule that when chance can thwart the exercise of skill and control the outcome of a game, chance predominates. And
so I want to make sure I'm clear that I understand what you're saying about the predominance test. Your argument is we can accept as undisputed that the second part of the game is skill, the nudging part is skill, and that even accepting that as a fact, which is a fact the trial court said, the way this game is set up is still barred by the statute.
Correct. There's no need to re-examine any of the facts here. Everyone agrees how these games are played. The only issue is how you apply the law to those facts. And it's this is a pretty straightforward application of the law to facts. This court has been engaging in this kind of analysis for literally centuries. And again, I would direct the court to the Lowe case, where this court confronted a remarkably similar fact pattern, where players could always receive a button worth several cents from using a device, and this court still held that chance predominated. And since I'm coming to the close of my time, I would like to say that because I have not addressed the pretext argument, we would stand by the arguments in our briefs, and we think there is an alternate basis to affirm the judgment below, because effectively plaintiffs failed to prove at trial that they're not running anything more than an illegal gambling ring. But as a final matter, I would like to call to this court's attention the amicus briefs that were filed by the Sheriff's Association, by the Association of Chiefs of Police, and by the Conference of District Attorneys. And in those briefs, they note that the trial court's judgment below not only failed to properly apply the state's video sweepstakes statute, it has also profoundly made it much more difficult for law enforcement across the state to protect North Carolinians from the many ills that stem from video sweepstakes operations. And therefore, unless there are no further questions, we would respectfully join with amici in urging this court to affirm the decision of the Court of Appeals. Thank you very much.
Thank you, counsel. Rebuttal.
Pardon me. I just want to briefly note that State v. Lowe, State v. Lipkin, those are not predominant factor cases. Those are lottery cases. And unlike gambling, which requires consideration, a game of chance, and a prize, lottery cases only require consideration and a chance-based prize. It doesn't matter if there's a game of skill or a game of chance. If you pay consideration for the opportunity to win a chance-based prize, it's considered a lottery. State v. Lipkin, those are all lottery cases. So those cases don't even involve the predominant factor test. And so we would hold those cases distinguishable. And of course, this case is not just like State v. Lowe, because in State v. Lowe, you had to pay for the collar buttons. In State v. Lowe, you could only get to the prize if you paid for the collar button. There was no free without purchase. So we would find those cases distinguishable. Second of all, the government has said these things are bad. We should be able to allege that these are bad. And as long as we think that this shouldn't be occurring, we think that people are wasting money, ignore the elements of the statute and instead just apply the preamble. And if that were the case, and if that were the law, all the General Assembly would have to do was to insert into every statute, all things bad are unlawful to the extent permitted by the Constitution. There are reasons that crimes have elements, and this statute very specifically prohibits one thing, and that is video sweepstakes promotions conducted through video games of chance. There is no statutory basis. You can't look in the statute and come up with this alternative argument that the government says. Finally, pretext. We have a finding. This gift surplus sweepstakes promotion is not designed to avoid applicable law. The defendants provided
Counsel,
no.
I'm sorry. I'm afraid your time has expired.
Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.